Our next speaker is Professor Nigel Banks from University of Calgary. As far as I know, he recently retired from 37-year-long teaching career. And now he is Emeritus Professor of University of Calgary. He has published so many journal articles, books, book journals in the energy law, natural resources law, and international environment law, including transitioning to a low carbon future. Today's topic is carbon capture and storage projects and the law of the sea. As you may know, the carbon capture and storage, CCS, is one of the debatable agenda in the UNFCCC negotiations. Please join me in welcoming Professor Banks with a big applause. Mr. Professor, please deliver your presentation.
Thank you, and good morning and good afternoon. Thank you for the invitation to speak at your conference, and I'm sorry that COVID-19 is still making it challenging to travel. So my outline here, I'm going to talk a little bit about an introduction to CCS, then talk about the application of the Law of the Sea Convention to CCS projects, and then move on to the London Dumping Convention and its protocol, and also reference OSPAR, the Convention for the Protection of the Marine Environment of the Northeast Atlantic, and then some short conclusions. So if we think about carbon capture and storage, it is a greenhouse gas mitigation technology involving the capturing of CO2 emissions and then permanent geological storage of those emissions so that they are not available to the atmosphere. We typically talk about the CCS value chain as involving the capture of carbon dioxide at large final emitters, whether those are power stations, cement industry, or other similar activities. The compression of that CO2 once captured, and then its transportation by pipeline or ship to a suitable injection site. And suitable injection sites include saline aquifers and depleted oil and gas reservoirs. And of course, we can think of both onshore locations and offshore locations, and they both have their advantages and disadvantages. The one significant advantage for offshore locations is that they don't generally engage the not in my backyard syndrome, the concerns of people in the immediate environment opposed to this sort of industrial development. Current offshore examples include two important projects on the Norwegian continental shelf, the Sleipner project, which involves the capture of carbon dioxide from a methane stream. So this is a natural gas stream that is contaminated with a significant percentage of carbon dioxide, which must be stripped out of the gas before it can be pipelined, and in this case is then injected back into the formation. And I think it's notable that that project has been running until since 1996. So we're not talking about an unproven technology here, which I think is often raised as a potential concern with CCS, but actually with a proven technology. And then similarly, the Snøhvit project further north on the Norwegian continental shelf. So I think one of the questions that my title raised is there anything new? There is in fact a significant literature on carbon capture and storage, both a technical literature, beginning with the IPCC's special report on CCS, and continuing with a significant amount of work undertaken by the International Energy Association's Greenhouse Gas Research and Development Program. And there's also a significant legal literature going back to the same period. So with an important early contribution from Karen Scott, who I think has either spoken at this conference or will be speaking. So I think the question is, what is new? And I think what's new is an interest in what are referred to as negative emissions. So this will be BANKES, which refers to bioenergy resources accompanied with carbon capture and storage, and DACS, which refers to the direct air capture of carbon dioxide and then its injection into geological formations. And I think most people consider that CCS is likely to be an important part of achieving net zero by 2050. And that's certainly the view articulated by the International Energy Association in its net zero report that came out earlier this year. And to meet that hope, we are also seeing concrete new projects coming along, and in particular, a number of projects on the North Sea continental shelf, both on the Norwegian side with the Longship or Northern Lights project, and on the UK side with the Acorn project and the East Coast Cluster project. In Southeast Asia, there is talk of a project north of Australia, which could serve as a possible Southeast Asian hub for geological injection. And we're also seeing increased collaboration between North Sea states in relation to CCS, and legally we have recently seen 2019 the possibility of the provisional application of an amendment to the London Protocol, which was something of an obstacle to CCS projects involving export of carbon dioxide. So just briefly on some of these projects, this first project is the Longship project, which involves capture at two facilities in southern Norway, one a cement facility and the other a waste incineration facility. Ship transportation of that to a spot near Bergen on the west coast, and then the pipelining. So the diagram on the right is showing the pipeline out to an injection site south and west of two producing oil and gas fields. So this is a project in its initiation that will involve simply emissions captured at Norwegian facilities, but it's expected that in future shipments will also come from additional North Sea countries. The Acorn project, a similar type of project, capture at various industrial facilities on the east coast of Scotland, and then either pipelining or tankering to the pipeline terminus where the CO2 would be shipped out to the injection facility. And then another project, which I think is even further advanced, this is BP's East Coast Cluster project. So the east coast of the UK, capturing from industrial facilities in the northeast, and then around the Hull area, and pipelining out and then injection. So to move then to the legal side of things, first of all, then in relation to the Law of the Sea Convention, and thinking about two things: the rights of parties to engage in CCS and their duties. In terms of the right to authorize CCS, it's clearly a responsibility of coastal states, and I think there is no doubt about the exclusive authority of the coastal state to engage in CCS activities, whether we're talking about internal waters, territorial sea, the exclusive economic zone, or the continental shelf, including the extended continental shelf. Things are a little less clear when it comes to the area but I think in practical terms, that's unlikely to be significant because we're not likely to see appropriate geological targets in the deep seabed. In terms of duties, I think the duties of coastal states obviously include their duties of due regard, their responsibilities as all states to protect the marine environment, and of course a particular interest in dumping and the question of whether or not injection into the seabed rather than on the seabed or into the water column actually constitutes dumping within the meaning of the convention. I think in practical terms, that issue is really dealt with under the London Dumping Convention and the and its protocol. And it's clear, of course, that the dumping provision of the convention stipulates that states must adopt national rules in relation to dumping, but those rules must be no less effective than appropriate global rules and standards. And those global rules and standards are found in the London Convention and the protocol. And as between the two, the protocol is much the more important because, of course, it will and does replace the convention for those states that are parties to the protocol, and ultimately the London Convention will simply drop out of the picture. The situation in relation to the London Protocol is that it clearly does deal with subsoil disposal operations, except those that are associated with oil and gas activities, such as the Sleipner project that I referred to earlier. And as we know, the protocol has what's called a positive list. That is, you can only engage in types of dumping if those types of dumping are specifically authorized by the protocol. And perhaps not surprisingly, carbon dioxide was not originally listed as a permitted waste stream, but the annex was rapidly amended. Indeed, at the first meeting of the parties to the London Protocol to permit CCS activities, and the parties have also adopted 2 sets of technical guidelines to provide advice to parties. There is also, though, Article 6, which prohibits export of waste for dumping. An amendment was also adopted very early on in the conventions, in the protocol's life, but it has yet to enter into force. And to turn to that issue, here's Article 6 of the London Protocol, simply states flatly, contracting parties shall not allow the export of wastes or other matter to other countries for dumping or incineration at sea. An amendment, as I've just said, was adopted in 2009, but this is an amendment to the convention rather than simply an amendment to the annexes, and it's therefore much more difficult to bring into force. But you can see that what it contemplates is permission to engage in CO2 disposal activities in the geological structures pursuant to an agreement or an arrangement entered into by the relevant countries, and the provision of that agreement or arrangement to the IMO. Under the amendment rules for the protocol, the amendment will only take effect once accepted by 2/3 of the contracting parties. There are now 87 contracting parties, but only 7 have actually ratified the amendment. And that led, therefore, in 2019 to a resolution proposed by the Netherlands and Norway on provisional application of the amendment. And that was adopted by consensus a little over 2 years ago, and deciding to allow for provisional application by those parties who have deposited a declaration to that effect with the IMO. And to date, only Norway and the Netherlands have deposited such declarations. The legal framework for that is, of course, Article 25 of the Vienna Convention on the Law of Treaties, which allows for provisional application in 2 circumstances: if the treaty itself so provides, or the negotiating states have in some other manner so agreed. And I think it's understood that a resolution adopted by consensus is a mechanism by which the negotiating states can so agree. The third instrument that I'll refer to is OSPAR, and again, OSPAR clearly regulates pollution, including dumping in the maritime area, and also provides a positive listing approach, and carbon dioxide, as with the London Protocol, was not originally listed as a possible substance for dumping. Once again, this treaty was amended as of 2007 to permit carbon capture and storage, and also the organization adopted a set of legally binding technical guidelines for disposal activities. And as I alluded to earlier, we're also seeing increased collaboration between parties with respect to the possibility of marine CCS activities. And so I refer here to a very recent MOU between Norway and the Netherlands, recognizing the increased importance of CCS in terms of achieving global climate goals, and indicating their intention, the penultimate bullet, to enter into a formal agreement this next year, dealing with remaining challenges to cooperative CCS projects. And presumably what they're thinking of here is an arrangement or an agreement which will meet the requirements for provisional application of the London Protocol. And as I said earlier, both parties have deposited declarations to that effect. The IEA is continuing to emphasize the importance of CCS or CCUS, carbon capture, utilization and storage. And I simply refer there to a recent report that they have completed in relation to the Southeast Asian region. So in conclusion, CCS is an option in the mitigation toolbox. It's not a silver bullet, of course. And one of the challenges has been very slow uptake. So interest in CCS seems to grow and wane in periods. I think we're in a sort of growth area at the moment, but the principal object has not been a technical objection. It's been principally economic, given the costs of the actual capture side of the technology. And I think going forward, we expect it to be, hope it will be, an important part of a net zero strategy. When we look at the legal rules, I think the Law of the Sea Convention provides a clear and appropriate allocation of authority for conducting CCS operations in coastal state marine areas. We've seen that regional and global dumping conventions initially presented a legal obstacle to CCS activities, but those obstacles have, I think, been successfully overcome. And at the same time, technical guidance has been provided to ensure that CCS activities are conducted in a technically safe and environmentally protective manner. And so overall, I would say a positive example of multilateral environmental agreements responding quickly to changing technology and opportunities and to address the threat of climate change. So thank you for your attention.
Thank you very much, Professor Banks, for your insightful presentation.